Thank you, Anil. And thanks to Right Horizon for giving me an opportunity to share some of my thoughts on the subject. This is something which is passionate for me for the past, at least in the last 4 or 5 years, ever since COVID came in, and I encountered many of my friends, relatives, etc., who have gone through hell as a result of this. So I hope I'll be able to communicate some of these issues. These are some of the learnings where, which I wanted to share, as well as some of the legalities involved. Just to give you a background, we are on a very sensitive topic here called inheritance and wills. Why I talk about sensitivity is that hardly anybody wants to talk about wills. The moment, at least if you take the statistics today available, less than about 10% of Indians have a will, written will available with them, as compared to almost 46 to 50% in the US. Why India? India is a very emotional country. I mean, I myself know many of my older relatives, etc. The moment you talk about will or inheritance, they typically are a little unnerved about the whole issue. Because they don't want to talk about death. They consider it a bad omen to talk about death. So, we need to change the system, because if you don't talk about it, we have a lot of legal consequences, which is there on board. If you look at the statistics today, I think the recent reports are that there are about 25,000 crore shares which are unclaimed, fixed deposit about 78,000 crores, employee provident fund about 54,000 crores, and about insurance almost 25,000 crores. That means almost 2 lakh crores of money is lying with the government, because people do not have knowledge about it. People do not have will about their wills. Their family is not aware of it. So ultimately, the government is enjoying this money. So that is where this whole picture comes into play, where this topic has to be debated. Let's spread this message that everybody needs to take a will. So I'll take you through some of the legalities first. There are two types of succession in India. One is an intestate succession, where there is a person has not left a will. That succession of their estate takes place to the legal heirs as defined under the Succession Act. There is the other part of it, which is the structured, which what we are talking about is a testamentary succession with the will, where if a person leaves a will and the succession of the estate happens in accordance with what has been left in the will. This is how this thing has been happening at this point of time. The process in an intestate succession where somebody has not left a will is primarily through a heirship certificate or a family tree in terms of the process. And then you have to move the court for a letters of administration or a succession certificate. Now, this is where the challenge lies, because if you have not left a will, obviously the family is not aware of many of these issues. It obviously takes into consideration the normal succession, which has class A share, heirs, legal heirs, which is predominantly the family and the children, this thing, and then it goes on to various other relatives, blood relatives, etc. The second process which we are concerned about today is the testamentary succession, where again it is based on a will which one has left. Now here again we need to obtain a heirship certificate or a family tree certificate. Now predominantly a heirship certificate or a family tree certificate is to identify who the legal heirs of a particular person are. Though a will may be specifying the legal heirs, at the same time, the law requires that at least a heirship certificate, many government agencies would require this to know if all the legal heirs are covered or not covered. Even if it is not covered, at least they are aware that there is a will, etc., so that you are taking care of those issues. So again, in terms of probation of a will, the will typically probated only if you have properties in Mumbai, Chennai, and Kolkata. Now, why this is so is almost 100-year-old issue. When the Indian Succession Act came into place in 1925, these three towns or cities were designated as important cities where the properties needs to be taken as a probate. Not necessarily in other places you need a probate of a will. A probate is predominantly the confirmation of the will by the court. So only if these are your immovable properties or if the will is made in relation to Mumbai, Chennai, and Kolkata, you need to get it probated. So what is a will? Let's look at what a will is. A will is as per legal terminology, is understood to be a instrument which is obviously in writing for disposition of one's estate or property. It comes into effect only after death of a person. So you could make a will, but the will is not effective until death. Slightly different from when you are gifting your property. When you're gifting your property at this point of time, during the lifetime, the property actually gets disposed from you pursuant to the gift deed into the third person. So here, the property belongs to the person who's making the will, who's known as the testator. He continues to be owning the property until he dies, and the will comes into force only when he dies. Who are parties to a will? Let's take the first person is, of course, the testator, the person who makes the will. He's the person who known as a testator. The second important person is a executor who is authorized under the will to be implementing the directions or the decisions contained in the will. The third person, which is the most important, is the beneficiary of the will. They are known as legatees in the will. These are your heirs or whoever who you want to dispose of your property. They are known as legatees, and the legatee has to be stipulated. Two witnesses is mandatory to make an effective will. Unless there are two witnesses attesting and signing as part of the will is considered to be invalid under law. So these are the four parties who are predominantly going to be considered in a will. The executor and legatee could be the same. So you need not designate a third person who's not part of the legatee. A legatee, as I told you, is the beneficiary of the will. Any of the beneficiaries of the will could be designated as an executor in the will, and that person could be given this thing for the will, to implement the will. You can also be a minor, and a legatee could also be a minor or an unborn child. But ultimately, the legatee must survive the testator, in the sense that if you have designated a person as a legatee and if that person dies before the testator dies, obviously that he ceases to be a legatee in that will, because the will is not come into operation. The will come into operation only after the death of the legatee, the testator. Here, the legatee himself dies before the testator. So he has to outlive the testator. One of the two legatees surviving in that case will get all the properties, or unless the will stipulates how the property has to move at that point of time. What kind of properties are distributable by a testator under a will? This is a very important subject, again, to be considered. If you have owned immovable properties in India. Now, why in India? Now, this is a very critical issue, which particularly people who have immovable properties, like NRIs who have immovable properties outside India, there, the laws of the respective country where the immovable property is there situated would be the place which defines how the succession in respect of that immovable property takes place. Not necessarily that you create a will in India for a property outside India. It need not be satisfying the laws outside India. For example, in the Middle East, until 2023, the Sharia law was applicable, including to any Indians living there, which means that the property gets distributed only to the sons, not even to the wife. A small portion goes to the wife, but a majority goes to the sons. And again, a small majority goes only to the females. But of course, the law changed in Dubai, etc., in 2023, where now, as per it goes to the immediate family, the Sharia law is not applicable unless there. But again, when you're talking about countries like US or UK or any other countries in the world, you need to have a separate will to make it effective in respect of those immovable properties which are situated there. Again, another property is the rights over a immobile property in India. Now, what are these rights? Typically, these are again rights arising through a will of your parents or whatever. If you are entitled to those rights, that is also something which you can move to this thing, but only after you are, it has crystallized in you. Those rights would have crystallized in you. You can pass on those through a will. The other thing which is generally distributed in a will are movables. Movables could be anything, any property, which could be shares, which could be jewelry, which could be deposits in a bank accounts, etc., are movables which a testator can hear. Here again, the predominant law in India is that the testator has to be domiciled in India. Now, domicile in India for the purpose of succession need not necessarily be a place of residence. It's a very cure. For example, there is a court decision in respect of a property of a person who had properties in India, but who never came to India for 45 years, who was living abroad. He happened to be an Indian, not a citizen, but an Indian origin. Even the court held that he was domiciled in India and he could have written his will could have been enforced when through a will in India. So that's a very distinct topic. So that is again something which is there. One thing which needs to be known is in India, many people take their properties jointly with their spouses. Now, even or in the single name of the spouse, even if it is taken in the single name of the spouse, it is not considered as the person's property. So the point is, as I told you, in a gift or where property is registered in the name of the spouse, it belongs to the spouse. Unless the spouse has left a will, how that is to be disposed of, it will not be effective there at all. So a spouse's property cannot be willed by a testator, even if the monies for that has been paid by the testator. Let's take the typical types of wills you find in India. One is a joint will. A joint will is a concept which has been there, for a long time, which is not practically implemented much today, where two people come together, may be spouses, may not be spouses, create a will jointly and dispose of their property in a manner they define. Now, again, the Supreme Court has defined a joint will as a will by two separate people, which is only contained in one document, is known as a joint will. Again, there is no hard and fast rule. A person who makes a joint will can revoke that joint will and make a fresh will, etc. All that is possible. Again, if you can make a joint will and it operates separately, why create a joint will? I mean, everybody would go in for a separate will for each of the persons. A slightly different concept, which is often confused with a joint will, is something known as a mutual will. A mutual will is typically made by husband and wife predominantly, where they will each other their respective properties. That's what happens. For example, the husband will say, it need not be, it may be contained in a single will, or it can be, and in that case, it is known as a joint mutual will. It can be contained in a separate, mutual will, where it can be in a separate document, each one. Now, here, there are different legalities involved in the context of a mutual will. For example, in the case of a joint will, I mentioned that a joint will could be revoked, whereas in a mutual will, it is not revocable, particularly when the property in respect of which you are getting the possession from the mutual will. Let's take a case: a husband and a wife executes a mutual will between each other, where they say that after my lifetime, my property is transferred to you. And typically, this is the language of the will. It's transferred to you, and thereafter, this will, after your life, it will go to the children. The wife reciprocally says that same thing, that after my life, all my properties vest with you as a husband, and thereafter, after your life, it goes to the children. Now, here the courts have interpreted, several times, that a mutual will of this nature, let's say the husband dies, and the property of the husband now vests with the wife. Can the wife tomorrow will it to somebody else, that property? The courts have held no, because there was an agreement between the husband and wife prior to their deaths that this is how the property should be moving. So a wife could probably, in respect of her property, will it to a third person, but in respect to the property she gets from the husband, is bound by the contract, and that cannot be willed to a third party at all. This is the concept of a mutual will. A life interest will, typically in a will, is where the husband or the wife, if they own an immovable property, decides that I would like to give this property after my life. I don't part with the property. I permit, a life interest in the wife or the spouse, whoever it may be, to live in that property for her life, and thereafter it moves to the children or X, Y, or Z. Now, a life interest, once it is given, unless that life interest ends, the legal heirs will not get into the property at all. Now, it's a very ticklish situation where the person can live there, but he cannot dispose of the property because he doesn't have a disposable right. The heirs do not have a disposable right in respect of that property unless there is a death of the person who has been given life interest in that property. So these are some of the implications which you will find in a life interest will. A conditional will is slightly different, where you will to a particular legatee to take possession of that property after your death, subject to certain conditions. That condition, obviously under law, that condition has to be logical, it has to be legal, it has to be a reasonable achievement, otherwise it may not sustain. That will may not be sustainable in a court of law. Predominantly, those kind of wills can stipulate a condition. I mean, I've seen people making a condition that unless you marry, that will not come into effect, or unless you take a particular qualification, you'll not get that will. These are some of the conditions one has seen in practical terms. Let's take the prerequisites for a valid will. A sound testimonial capacity is one of the fundamental pillars on which a will can be made, which means the testator is 18 years of old age, which that is a major, and a sound mind. A sound mind person only can be disposing of the property. Again, what is a sound mind? Typically, a person of sound mind is a person who understands the manner of property distribution. So a person, when he's making a will, he should be in a capacity to understand what is property distribution and what is he doing in terms of this thing. Is he able to understand the extent of the property distribution? Whether he is giving to X, Y, Z, etc., how much he is giving, is he able to do it? When he is including somebody as a legatee or excluding as somebody as a legatee, does he understand the implications, why he is including and why he is excluding? These are some of the important aspects to be looked at when you look at as a testimony capacity. Now, there can be issues where, for example, can a person with dementia be able to, make a will? It's a very, legal question in terms of dementia, because a person with dementia again depends on how much of, loss of memory the person has. Again, if he is able to understand, and that is subject to a doctor's consent. Legality, yes, it is possible, but whether, in most persons with advanced stages of dementia, when they are in an advanced stage of Alzheimer's, etc., they do not even recognize who people are. They are not able to sign, etc. There again, the question of making the will is definitely doubtful, can be challenged. There was a particular case which got decided strangely, for a minor or for a disabled person. There are laws which are applicable in India, where, a guardian can be appointed, etc. Unfortunately, a person with dementia or a mental disability is not considered as a disabled person under any of those laws. So the Bombay High Court, in a case which happened in January 2024, had to decide how this can be done. Here, the typical facts of that case was where the person with dementia could not do it. His wife is again an aged person. She also couldn't address it. Their children had to move the court, and the Bombay High Court in that particular case decided that the property can move in that direction based on medical evidence, etc. Appointed him as a custodian of the property, one of the sons as a custodian of the property, despite the fact that the law did not provide for that. So these are some of the things which we need to keep in mind. Other prerequisites for a valid will is that the will should not be made through a fraud or a coercion. This is one of the most important aspects which has to be kept in the context of a will. The testator has to sign in the presence of two witnesses. That's very important, because ultimately the both witnesses also will have to attest and sign, saying that the testator has signed in their presence. So ideally, the witness should not be two different people signing at two different points of time. If they are doing that, and if that will is challenged, ultimately it can be questioned. Of course, all these questioning of will happens only when there's a dispute arising, but otherwise it's not going to be a problem at all. Again, whether the will has to be signed on each page, it is not mandatory, but it is recommended, so that people who are making the will do not change the will or something of that sort, or at a later point of time. So it's ideally do it as a recommendation. He at least initials or signs every page. What are the safeguards while making a will? One of the fundamental principles that you revoke all earlier wills. So if you have made a will earlier, all those earlier wills will have to be revoked. Again, you have to describe the legatee and the executor very clearly. Identification could be done by their name, their passport numbers, their Aadhaar card numbers, their PAN card numbers. Ideally, if all three are available, put all three in the will itself, so that there is no dispute in terms of what their identity is at that point of time. Describe the properties and distributions very clearly. Yes, I mean, it is advisable to describe the property at least in a little bit of this thing, but not recommended for, it's not mandatory, but it is recommended. Again, the concept of registration is not mandatory under law. It is not mandatory under the Supreme Court guidelines. It is, if you see all the websites of all sub-registrars, they contain that registration of wills is not mandatory. It is optional. However, what practice which I've seen today is almost all registrars across the country are taking a view that unless a will is registered, this has to be probated, and they ask you all kinds of this thing, details of the property. It puts a whole lot of implications on all the legal heirs ultimately for enforcing these wills. I myself am facing this at this point of time for a very close friend who passed away, due to a terminal illness. I had drafted his will for him and settled the will also, despite the will being, not registerable. Again, we are facing a whole lot of challenge in terms of, so I think ideally one has now come to the conclusion that registration is almost recommended, strongly recommended, particularly if you have immobile properties moving on to the legatees in the future. That's nutshell what I've taken you to the will. Now let us take a very important topic which comes for discussion often, is that if I've given a nomination, should I really make a will? 100% you should make a will, because a nominee is only a facilitator and not a legal heir under law. Because a nominee, except in one or two circumstances, which I'll come to this thing, typically a nominee, courts have held, is holding the property in trust for and on behalf of the legal heir of the person who has estate it belongs to. So a nominee, even if it is for shares or whatever, even if you get the shares transferred in your name, if the rightful legal heirs come to you, you have to part those property to the legal heirs. Unless, of course, you happen to be the legal heir and the nominee, yes, it's facilitated. But does that mean you should not give a nomination? No. Please, for having, always give a nomination in that context, whether nomination is there or no. Now, even the law has changed. For example, you can nominate one person or two persons, etc. In fact, for fixed deposits or things like lockers, etc., the nomination was only permitted to one nominee until recently. A recent bill which has come into play, which has been introduced in the parliament just a week to 10 days ago, provides for multiple nominees to be appointed there. So here again, that is possible today. So please appoint a nominee, but the legal heirs get it. Another important concept is the priority for beneficial nominee in insurance. Now, I'll come to that a little later in this next slide. What are the risk mitigations to protect the family from certain events? For example, one of the things when we talk about a will is not a trust, a family trust. If you want to, so when the legal heirs get hold of the property after the death, is he obligated to all the creditors of the person? Definitely. So if the testator has borrowed money from third parties or whatever, from banks, financial institutions, for whatever purpose, definitely the family member who's getting the heir or the legal heirs who's getting the property has a legal obligation to part with that property to this thing or pay off those debts. So one of the methodologies which is used often by families is to create a family trust. In a family trust, unlike in the case of a will which operates post the death of the testator, in a family trust, the family assets are moved to the trust itself upfront during the lifetime of the testator itself. The trust thereafter designates beneficiaries of the trust. Once you do this, typically, you have ring-fenced the family assets, and there the debtors or the creditors, etc., may not be able to claim anything from that property. Again, if it is done with a devious intention to defraud the creditors, etc., it may be looked differently. Again, this is what you've seen people like Vijay Mallya, etc. Today they have declared themselves bankrupt, but they're still enjoying huge properties outside India, etc. They're all under trust. So nobody can touch it in terms of the trust, despite the fact that he owns money elsewhere. Another particular important provision which most families are not aware is an insurance. When you take a life insurance, there is an option available under Section 6 of the Married Women's Property Act. This act is almost 100 years old or more than 150 years old. Section 6 of this act provides that any person who takes the insurance policy under Section 6, you have an option with all the insurance company to take it under that. In that case, that property automatically gets converted into a trust property. So otherwise, let's take a term life insurance. Even if you get that term life insurance benefit to you, your creditors would be able to claim that term life benefits from you out of the benefits. But when you take a policy under Section 6 of the Married Women's Property Act, it is beneficial to the spouse and the wife particularly. It can be done only by husband to the wife and the children. Mind you, this doesn't protect the parents of the person who's dying. It protects only the wife and the children. Their property is ring fenced automatically as a trust. Unless you you stipulate who's going to be the trustees in the insurance policy, in that case, that will go. Otherwise, it will go through the public trust itself, where there is a system available. You can ask your insurance agent, they'll be able to guide you on those issues. Again, one thing when we are talking about insurance, when we are talking about protecting your family's interest, when you take an insurance, for heaven's sake, please disclose everything you know, every illness you know, every hospitalization which you've gone through, everything will have to be done when you take a will. I have a particular instance recently, 3 years back, which has happened. One of my person whom I'm guiding as a stepdaughter is actually, she lost her husband during COVID, a young couple. She was hardly in her early 30s, where the husband had taken a term life insurance. And he took a term life insurance just 3 years back. And in that term life insurance, he did not disclose that he was hospitalized for 24 hours in a hospital, and that the insurance company found out and rejected that entire insurance claim. Now here, of course, I did fight with the insurance company, and ultimately, based on my fight, not as a legal, I actually wrote to the board of directors of the insurance company, claiming ethical violations, integrity violations, etc. And the entire proceeds of that this thing, after 1.5 years of this thing, was given to the widow. But here, the reason why that was there, again, the insurance law has changed slightly in 2015. Under the Insurance Act, any insurance policy can be rejected only within a period of 3 years after you have taken the policy. After 3 years, even for fraud, you cannot reject the policy. So I use that particular provision where the death happened within 3 years, but the rejection happened after 3 years. On the basis of that, we are able to get it. So this is a very important aspect which you need to do. Again, in the context of a marriage, please renew your will. If you've made a will when you're a bachelor, please renew your will after you make a will. And nominations also, please do it after marriage. These are some of the things which you need to keep in mind. Again, it's a very strange provision for Hindus. Marriage does not automatically revoke a will. Whereas for other religions, a will is deemed to be revoked automatically upon marriage. I do not know why Hindus are excluded, but anyway, keep this in mind. If you've made a will as a bachelor, or if you've done that, please renew nominations. And these are some of the areas where you find disputes happening between the parents and the wife, etc. Of course, these are sensitive issues. We have seen this discussion even among the armed forces, where parents and somebody died in action, etc. Yes, on a legality principle, this is how it works, but we may need to keep that in mind. Other safeguards in the context of inheritance, not necessarily in the context of will, is details of all investments and accounts has to be maintained. So one of the things which we find here is that I had a particular case of a friend whose father died about 15, 20 years back, and he got a call from somebody who claimed to be from the this EPF fund, which is the benefit fund where all the unclaimed shares are deposited. There, he got a call from somebody saying that your father has left X amount of shares which are valued at 20 crores. And none of these three people were aware of this 20 crore shares. It took him almost 4 years to get hold of those shares. Again, because there were three brothers and sisters, and all those things will have to be done. So here, keep a record, at least in soft copy, hard copy, updated on a day-to-day basis. All investment and account details need not necessarily be part of a will. If you don't want to share it, at least the property details, at least mention it. But this can be kept separately so that somebody has an access to that. Another thing is all original property documents. Again, I've seen cases where original properties are not traceable by the legal heirs. So again, keep it in a safe place, tell the people where it is kept, etc. These are very important. Safekeeping of all and sharing of passwords. This typically, even in my case, even during day-to-day times, I keep forgetting my passwords. I have told my daughter actually to keep all my passwords. It's a very challenging task because you have so many passwords, you have so many accounts, you don't know which passwords there. I also know of cases where friends have passed away and their family has no access to their social media accounts, their LinkedIn accounts. They have no access to their Twitter accounts. So how do they close it? They can't close it. So unless these passwords are shared and kept it so that your heirs will be able to do it. Collect transfers recorded, vehicles. This is a particular thing not necessarily related to inheritance. It is more to do with when you are selling a vehicle. Please understand that if the buyer of the vehicle do not register the RC book or registration certificate in their name and the registration continues in your name, you could be held liable for all liabilities in the case of a death happening or a vehicle caught with smuggling, etc. You could be hauled even if you have sold your vehicle 20, 30 years back. So when you are selling a vehicle, please ensure to collect from the buyer the registered copy of the changed RC book. You should have it in your possession so that you can at least de-risk your, mitigate your risk in terms of this issue. There was a case in the Supreme Court recently of the similar issue where somebody, after 20 years of sale, was still hauled up for the indemnity insurance because the original purchaser had sold it to several times and they had not changed the RC book at all. Coming to a very important topic, which has created something known as the living will. What is a living will? Actually, a living will is a misconception under Indian law, at least, because typically when you talk about a will is not something which comes into operation during the lifetime of the person. It comes to operation only after the death of the person, as I mentioned. So it's a misnomer to call it as a living will. So the Supreme Court happened to consider in 2008 a judgment which was filed by an entity called Common Cause. It was an NGO. They filed a case in the Supreme Court where the predominant argument was that a person should be able to practice euthanasia, kill himself, which is practiced in many countries in the world, whether that permission should be given or no. The Supreme Court there is no law in India for that matter, but the Supreme Court definitely came to the conclusion that a passive euthanasia is permitted, but an active euthanasia is not permitted. For example, if a person is living and he wants to be injected with this thing as a committing suicide or something of that sort, if he wants a medical fraternity to give him a poison or something, that is not permitted. We have a famous case of a rape victim in KEM in Bombay, which has been there for 40. She was living as a vegetable in the KEM hospital for 40 years. And the hospital and the staff looked after her for 40 years, but she was blank. She was in a coma. But even in that case, the court did not permit her to be killed. So you cannot do that. But the court did consider something known as a passive euthanasia. So here, the living person can communicate that his wish, in the context of through a document or an instrument, not a will, I don't call it as a will, through a advanced medical directive. So he gives an advanced medical directive that he do not wish to be given permitted, he must be permitted to be given passive euthanasia. Now, let us understand what the Supreme Court decided in terms of that issue. Of course, this directive by the person can be revoked anytime during his life or can be modified any time during his life. But once it is there, this is how it will operate. So how does it operate? The person just signs it. Similarly, there are two witnesses and all those things are this thing. Manner of execution. Now, this is the manner of execution a medical directive. It has to be signed by the testator. I'm sorry, I think I've provided an executor. It is signed by the person who is executing it, and countersigned, again signed by two witnesses. Again, it has to be countersigned by a first-class judicial magistrate of the jurisdiction in which the person is residing in. A copy of the same has to be given to the family. Copy has to be given to the local governmental authorities like municipal authorities, etc. There are procedures available. It has to be given to the family physician as well. The copies, not that they are involved in executing the directive. Again, the medical directive has to be, once it is submitted to the local authorities or the first-class judicial magistrate, they are obligated under law to preserve it in a particular custody. They are recorded like a registrar's office, etc. They are maintained there until it has to be, becoming effective. Now, how does this medical directive becomes effective upon the terminal illness or when there is a requirement for this to be evaluated? It becomes evaluated. It's a very complicated process. It's not so simple as one is imagining it to be. It can be effective only with the unanimous consents of all these people. What is a unanimous consent? That means even if one authority does not consent, that effective directive cannot be given effect to. A close guardian or a close relative named in the AMD has to be consenting. Yes, we need to give the work. I'll tell you how that works also, because I've seen it happening in the recent past. Treating doctor has to give a consent. The treating doctor in the hospital who's treating has to give a consent. A medical board has to be constituted by the treating hospital, which has a group of doctors. Those group of doctors will ultimately consent or have a unanimous decision whether this AMD can be given effect to. And finally, there is a medical board constituted by the district collector as well of the jurisdiction in which the medical directive has been registered. So it is very easy to talk about living wills, etc. as a conceptual theory. It is there, but whether it can be implemented, whether it can be how easy it is implemented. I don't think we have seen a situation where this can be done or no. I don't think there's only one doctor who, apparently it was there in the press also recently, who actually gave a directive in Bombay, is what I understand. I do not know how many has been, but whether it has been executed up till now, I don't think there are any cases which are available of any execution which has happened on this basis at all. So that comes to the end of the presentation.